So tonight we have Jason Morris here. Welcome, Jason. Jason, thanks for joining us. Why don't you tell the group a little bit about who you are and what you do?
Yes, Jason Morris. I'm a law partner at Woodburn and Wedge, a local law firm. Born and raised here in Reno, attended Galena High School. Went away for school to BYU. Received 3 degrees there, a bachelor's and master's in accounting with a tax emphasis and a law degree. And I got all of the degrees at the same time, which really upset the Nevada State Bar, because when I went to apply for the bar exam, I did not have a degree, and so they looked at me like, who is this guy thinking he's going to take the bar exam without any degrees? But it was just part of the joint degree program, and I really enjoyed doing estate planning, which is my main focus at Woodburn and Wedge. With estate planning, I do probate and trust administration. So we catch people either in life or at death if they don't do planning. So, and we'll get into that more today.
So what made you get into this line of work?
So there were several other attorneys here locally who were mentors or family friends. I saw their lifestyles and the way they were very involved with their families, and I thought, that seems like a pretty good gig if you can still, be out on the boat on Saturday and still teaching or coaching your kids' Little League team. I thought, that seems like a pretty good lifestyle.
Yeah.
So.
And here you are.
Yes. Yeah.
Okay. So just to get right into it, what is the difference between, so a lot of people talk here about the importance of creating a will and having a will. So what is the difference between a will and a trust?
So both a will and a trust provide for the distribution or disposition of your assets at your death. If you have a will, that will have to be probated. Your estate will have to be probated. If you don't have a will, your estate will have to be probated. And we'll get into probate a little bit more detail and depth, but that's a very expensive, time-consuming process. For us as attorneys, we like probates. It's lucrative. Okay, a lot of mandatory filings, a lot of things that have to occur with the court. So it benefits attorneys quite a bit. You can avoid probate with a trust. And a trust would hold ownership of your assets. And by holding ownership of your assets in a trust, you can bypass the probate process and have a successor trustee come in and provide for the distribution of your estate and assets.
Okay. So do you need them both?
Yes. So even if you have a trust, you should still have a will. And I blame my clients for that reason, because we hope you take title to all of your assets in the name of a trust. If you don't, and an asset has to be probated, well, the will directs how probate will unfold. The will provides, typically, if you have a trust, that the asset gets poured over or distributed to your trust. So even if you have a trust, you still need a will as a backup document. But if everything's titled appropriately and owned in your trust name, then realistically the will becomes unnecessary at date of death. But we do it as a backup or protective mechanism to have that will just in case people go out and don't take proper title to their assets.
So are there any instances where a will and a trust conflict?
Certainly they can. Ideally, if you've done a trust, the will works in conjunction with the trust. If your assets are owned in trust, the will have no bearing on those assets, will have no say in their disposition. Similarly, any accounts with a beneficiary designation, the will, the trust, won't have any involvement with those accounts or assets, such as IRAs, 401ks, life insurance policies. So you can have the most artfully crafted, beautiful will, but if your assets have beneficiary designations on all of them or are owned in the trust, the will won't have any say or involvement in those assets.
Interesting. So do you have any good examples of, real life examples of when that?
Yeah, I guess, we've got a case going right now in our firm where a gentleman had prepared a trust and what we call a pour over will, meaning everything in the will in his probate estate would pour over into his trust. Problem is, he went out and did a handwritten will after he did his trust. And for anyone who wants to know, yes, you can do handwritten wills in Nevada, and I encourage you to do so because it will lead to future legal work for me and my profession. So
Job security.
it's yeah. So you might as well cut a retainer check now to your favorite law firm because it's going to lead to a conflict or dispute. So he tried to override his trust with his handwritten will, and there's just very conflicting terms in terms of who gets what, when they get it, how they get it, and honestly, I can't tell you how it will be resolved. But the do-it-yourself planning generally is not the best idea.
Right. So I guess a lot of people may have this question. What are the costs involved in setting up a trust?
Yeah.
A will, right? You scribble some stuff on a piece of paper, you get a notary, boom.
Well, boom, and then you're going to, again, that's a continuing attorney employment act because it's going to lead to a fight if you do it yourself. But you can do that. Typically a trust package, which would include revocable living trust, will, powers of attorney, and then we help you fund the trust in terms of moving your assets into the trust. You're looking at several $1,000s, $2,000 up. I mean, it's pretty tough to do the trust planning package for less than several $1,000s.
Does it depend on how much money is going into the trust, or is it just sort of a flat fee?
Yeah, that's a good question. A lot of people think, well, I don't want to tell Jason all that I have because he's going to charge me more. It's really not so much the amount of your assets or the value, so much as how many assets you have and the complexity of your distribution plan in terms of who gets what, how they get it. If there's a lot of different contingencies, if Tommy dies, it goes to Billy and Bob. If Billy and Bob dies, it goes to Sally and Stevie. I mean, just the permutations get to be more involved, and so that would really drive up the cost more so than the sheer size or value of the estate.
So what does the process entail? How long does it take? I mean, tell us more about the process.
Yeah, so typically I have an initial sit-down consultation with clients. I like for them to come in prepared with their complete asset picture and not hiding things from me or holding back on information because that doesn't help. But usually we discuss where they want their assets to end up. What do their assets look like? And then I need them to provide me copies of deeds to their properties, real properties, account statements, motor vehicle registrations. And then from there, we can go about drafting the documents, have them come back in and sign and execute. The biggest roadblock tends to be the clients providing me the asset information. Either they can't find an account statement, they can't remember if they ever received the deed for their timeshare in Honolulu, and so it just becomes a tough effort on the client's part to gather the asset information. For younger couples, sort of my wife and I, our age group, it's figuring out who's going to be the guardian for minor children. That is a big, big hurdle for young couples because no one can raise children as well as the parents can.
Right.
And so it's very difficult for them to choose those guardians.
Okay. So what do you...
I didn't totally answer. So it can be done in a day's time.
Right. It
If
depends
people
on
come in with the information.
Right. But I would think a lot of people wouldn't have that information. I mean, you would assume that people would, but I could see how people would have to really hunt to gather all of that. So is that, and if not that, what is the most common reason that people put off creating a trust?
The biggest reason people put it off is because they're immortal in their own mind. People just don't want to face the reality they're going to die. And it's particularly men, I find, are the least likely to want to confront that issue. It tends to be the wives who are driving the planning. And so I can't tell you how many times I sit down with men and they don't want to face the reality. They don't want to plan for the inevitable. So that would be the biggest hurdle. People just think that it won't happen to me.
Right.
Won't be
So do
mine.
you find that people come to you like in panic mode? And then, I mean, what is the toll that takes on everyone?
Yeah, and this is painting with broad strokes here. Please don't misinterpret this, but the older generation tended to be very traditional in their roles. The men would handle the finances, the women would maintain the house. And I work with a lot of women typically outlive men, who just don't know the status of their financial affairs. So that's the big roadblock.
Right.
They don't know what's out there. They don't know what they need to live off of. Hence, it's good to have a good advisor, a good financial partner.
They don't know where to find the information.
Yes. So women tend to be the ones who come to me in a panic, as you described. Most men, it's like they need a child to come in and say, "Dad, you got to get this done. You know, you're at that stage in life, Dad, where it's timed. You need
It's good
this."
to know.
So
Get the kids involved.
that helps. That helps a lot.
So I think there's a common misconception that you have to be a millionaire to have a trust. So, I mean, who not qualifies, but at what point, what makes sense to put in a trust? At what point do you say, this makes sense for me?
Yeah, good question. The common metrics I use, if you own real property in more than one state, you should have a trust. Because if you die owning real property in multiple states, your heirs will face probates in multiple states. So I'm licensed in Nevada and California, and if I hear a client come in and we're talking about potential probate estate with real properties in both those locations, I'm like the jackpot. You know, I'm like the jackpot wheels. The dollar figures are just spinning in my head with the amount of fees that are going to be generated with that. So, real property in more than one or more states, two or more states, excuse me, that makes sense to have a trust. Or, under Nevada law, if your assets are $300,000 or more, it makes a lot of sense to have a trust. Because at $300,000, you face what's known as a general probate administration, which is the most expensive, most time-consuming type of probate here. I tell people budget $5,000 in about a year's time in Washoe County. And that's if everything goes well. So those are the two circumstances. And then the third one would be if you're in a second, third, or fourth marriage or beyond, and you have children from prior marriages or relationships, you need a trust.
You need more than a trust.
I don't think there's a marital counseling component to this workshop, but
I'll
maybe
see you
for the
after
next
the
round.
show.
For the next round of lectures, we get a counseling.
Yeah. So, I unfortunately lost both of my parents, and my mom had a will. Before she died, we found it, but it was way outdated. My dad never had one at all, so I can relate. And, you know, unfortunately, in times like that, the combination of emotions and money, it's not a good combo.
Sure.
So at the last minute, we had to update my mother's will. So it goes back to how often, what's the protocol or what's the general rule of thumb for how often you should update your trust?
Well, if you're my client, I hope it's as often as possible. But in all seriousness, birth, death, divorce, marriage, those are all seminal life events when it behooves you to review your estate plan. Birth, death, divorce, marriage. So, you know, beneficiaries change, who you've named as an executor or trustee has changed. All important times for review. Or if your financial circumstances have changed.
Right.
If you've fallen into an inheritance or
lost properties.
Yeah, lost assets. Fortunately, we haven't had to deal with that as much recently.
Right.
Also, tax law changes. The taxes have changed significantly since I was in school, and I feel like I have this master's in accounting degree, but it's kind of worthless now because so much has changed just in a matter of 10, 11 years that I've been out of school now. So any of those events would be a time to review and update the plan.
Okay. So someone that you love or someone passes away, they don't have a trust. What are the top 3 consequences that you see happen?
They're going to pay an attorney a lot of money.
Yeah. They won't.
The estate will. Yes, the estate will pay the attorney's fees. There's going to be a delay in accessing the assets or accounts. And oftentimes, there are going to be unknown creditors or predators who will surface. One of the kickers with probate is you have to invite creditors to come in and make a claim against the estate. It's a public proceeding in which creditors or predators, just bad actors out there, will come in and make a claim against the decedent's estate. So those are some of the...
So then what happens?
Well, provided the creditor has a legitimate claim, they will be paid out of the probate assets, the estate assets. There's just a lot of delays.
Okay, so probate. Not everybody,
Sure.
maybe some do, but maybe some don't. What is probate?
Moneymaker for attorneys. Number one.
It's a common theme I hear.
Yeah,
Jason.
yeah. Probate, honestly, there's just statutory steps that have to be followed. So the Nevada revised statutes, our state laws, mandate a number of things that have to occur with the court. In order to do that, you often have to appear in front of the probate court. There are hearings in which you have to essentially make your case or state your case. And those hearings, unfortunately, are not readily available. Right now, from the date we file a probate pleading, we're 2 months out for a hearing date. And so it's just a long delay.
Right.
But the purpose of probate is to make sure, in theory, that the decedent's assets go to the rightful heirs, the rightful parties. People will have their quibbles about who those rightful heirs
Yeah,
and
how do they
beneficiaries should be.
determine that? Is it like a trial where people get up and testify?
Yeah, the statutes build it in. The statutes build in the provisions and who gets what.
Okay.
And for the most part, it's fair. Okay. I mean, if you have descendants, you have children or grandchildren, they would be the ones who receive your assets. But there may be situations where you don't want a child to receive an equal share as the other children,
Right.
or you don't want a grandchild to receive assets as a 14-year-old. So, probate is it's like the sledgehammer, right? It's a crude tool to provide for the distribution of the estate, whereas you can be a little more surgical, a little more precise with even a will, but more specifically with a trust.
Well, I think we'd all like to live in this imaginary world that we're all going to behave properly when something like this happens, and that we all have perfect families, but the reality is we don't. And to your point about maybe there's a family member, a child or a grandchild, for whatever reason, they could be extreme reasons or not, that you would rather not receive any of your estate. Can you give us some examples so that everyone out here can kind of relate and say, wow, that's a good point?
Yeah, so when we talk about, I guess reading that, we're talking about disinheriting a
Yeah,
child
like what
or
kind of,
grandchild?
I guess I want to hear some examples of when the probate kind of went sideways
Oh.
and why you don't want to go there. Point.
I mean, I hear that question, give me some bad examples of probate. And I'm like, well, which case do you want to hear about?
Yeah.
I mean, because it's literally pick
Give us
your
some good
poison.
juicy ones.
Well, they're all juicy in a way. I mean, the most recent one was a very wealthy couple, husband died. He had a very outdated will that went back to the early 90s from New York. Died here in Nevada. Large estate, $16 million. At the time he created his will, the estate tax exemption amount was a mere $600,000, meaning that was what you could transfer free of any inheritance tax. His will was very odd in that it provided that whatever the estate tax exemption amount was at the time of his death was to be set aside for his children before his wife got anything. Well, the estate tax exemption amount today is $5.49 million. So $5.49 million came right off the top to his 2 kids. We talked about it with the kids. They agreed to say, we don't really need this. It should go to mom. The son, at the last minute, backed out on the deal. Hired an attorney, gummed up our probate proceeding, and it's now blown up into what would have been probably a $5,000 probate because we had this agreement, we reached these terms. I mean, I don't even know where the fees will end. It's going to be a lot of time and a lot of expense to settle out his claim and to essentially fund this bequest to the son and daughter of $5.49 million. And it just didn't need to happen.
Right. And when you think about, people factoring in the cost of establishing a trust and they, nickel and dime that compared to the thousands and thousands of dollars, that can be incurred if something, if it goes into probate, and not to mention the emotional stress.
Absolutely.
Right.
Yeah, absolutely. It is the, an ounce of prevention, a pound of cure, and it's tough because, it is an expense. I don't want to minimize it and trivialize it. I mean, we're talking real dollars for the expense of creating a trust, but the savings are significant down the road.
Right. So are there any tax advantages to setting up a trust?
Yes, and I sort of had my brain picked a little bit earlier for some tax planning ideas. One of the biggest benefits is we're a community property state in Nevada, and to the extent you hold assets in your trust as a married couple, upon the death of one spouse, the surviving spouse receives a full step-up in basis for the assets. Meaning, suppose my wife and I purchase a home in Reno for $200,000. It appreciates to $500,000 when I die. My wife gets to step up the cost basis of $200,000 up to $500,000, such that if she needs to sell it, she can sell it at little to no gain. And the house, there's obviously a gain exclusion for principal residence, so let's put that to the side. But that's true for any appreciated assets in your trust estate. And so it's a big benefit for a surviving spouse. And then when that spouse dies, the surviving spouse, there's yet another step up in basis at her date of death, assuming it's the husband who goes first and the wife survives. So right then and there, there's a pretty nice tax benefit, an income tax benefit. Not to mention there is an estate tax savings possibility, which again, the estate tax doesn't reach many folks these days because 5.49 million is our exemption, and that's per decedent. So a married couple can transfer up to $11 million free of estate taxes. Next year, that number goes up to 5.6 million.
So that leads into another question. So there's the whole gifting. A lot of people from a tax perspective consider. So what is the difference between, or are there any advantages to leaving it in the trust versus gifting?
Yeah, so our paradigm has shifted as estate planners. My whole training in law school and even undergrad to an extent was we want to gift assets out of our clients' estates because the exclusion amount was about $1 million, 1.5 million at that time. So that touched a lot of people, just between a home, some investment accounts, some life insurance proceeds, you could exceed $1.5 million, $1 million pretty readily, especially when property values were really strong here. These days, because the exemption amount is so high, we want folks to keep assets in their estate such that when they die, they get these step-up in basis benefits. It used to be we wanted to get rid of the assets so we weren't facing the estate tax, but because the estate tax exemption amount is so high, we're now doing more income tax planning to avoid potential income tax consequences to the current generation or the next generation when they inherit the assets.
All right. So is there anything else that you feel like the audience needs to know before we wrap it up?
I would tell you, because of this paradigm shift that I've mentioned, if you have highly appreciated assets and you're not going to face the estate tax, don't give them away. I see too many folks later on in life trying to sign off a home to Sunny or Sally.
Or Cher. Sorry.
Cher and Sunny, yes.
Sorry.
Don't do it. Keep the assets in your estate. If you have highly appreciated assets, you're not going to face the estate tax. Keep them in your estate such that when you die, your heirs receive this step up in basis. They'll be able to sell them at very little capital gains tax and derive the best after-tax benefit.
Okay, the most important question of the evening. What is the best $100 you've spent in the last year?
Yeah, so we took a little road trip for fall break to St. George, Utah, and we towed a boat out there to try to get in some last hurrahs for the season. On the way back, didn't quite time the gas stops too well.
I know.
So I say we didn't run out of gas because there was still some in the tank, but we were going to run out of gas 30, 40 miles away from Tonopah. So I had to pull over to the side of the road on this ranch, went up to the door, this very long driveway. They said, sorry, we don't have any gas. Our farmhand quit this week and he stole our 100-gallon gas tank. So I was devastated. But he's like, but our neighbors down the road, and they were probably 3 miles away, he put me on his four-wheeler, took me down there,
Nice.
and so I spent $40 on gas for, I don't know, 4 or 5 gallons, but it was well worth it to get some gas in our car and be on our way and make it to Tonopah. So
Well, good for you.
we weren't stuck in the Nevada desert.
And you got to ride on a...
A four-wheeler, yeah, I got a four-wheeler ride.
All right, any questions? Yes, Nate?
So some of us may not know, what do you mean when you say step up in basis? Can you define that?
Yeah, just again, so you purchase an asset and that's your cost basis. So say I invest, I'll use Greg since he's not here. I invest 100K with Greg. He earns a great return consistently over the years to where that asset has a fair market value of $200,000, that investment. At my date of death, my heirs get to receive that asset at the date of death, or the step up in basis, the date of death fair market value. Whereas if I gift that asset, that $100,000 investment during my life, they take my carryover basis. So they get my basis in that asset. Even if it's worth $200,000, they've got my $100,000 basis, such that when they go to sell it, they're going to recognize capital gains between the fair market value and the cost basis. So the step up in basis occurs at date of death, provided the asset's in your estate, and it bumps it up so that it can be sold for little or no capital gains. Yes?
So if you have life insurance and you want to name your spouse as a beneficiary, is there any thoughts on strategizing maybe giving the money to the trust as an entity? Is there a tax advantage to doing that?
Now, should we be repeating the questions on, can they pick that up?
Yeah. Say what?
Should we be repeating the questions? Can they hear it on the...
Can everybody hear the question?
Okay.
Okay.
Typically, if it's a joint trust, there's no advantage to naming the trust as the beneficiary on life insurance. Might as well just name the spouse as the beneficiary on life insurance. Again, that's painting with broad strokes, because not knowing your situation, if you have a taxable estate, you may not even want to name your spouse as the life insurance beneficiary. Maybe you want to name a grandchild or a remote descendant, because your spouse may not need those life insurance benefits in her estate, such that when she dies, that would be taxed at a 40% rate. So pretty case specific, but generally speaking, if you have a joint trust, don't necessarily name the trust as the beneficiary, as the primary beneficiary, just name the spouse. The trust could be named as the contingent beneficiary, because usually the trust is going to provide for different contingencies in terms of, what if this beneficiary dies? Where does the assets go? What if my son dies? Do I want it to go to his grandkids? Or it gives you more variables to play with. Yes?
So if you have a trust set up, but you've forgotten to include one particular asset, is that one particular asset subject to probate?
Yes, it is. And it depends on the value of the asset. So there are different tiers of probate. So from $25,000 and less, simple affidavit procedure, one pager, do it yourself. People will screw that up too, but we'll come in and fix it as attorneys after. From $25,000 to $100,000, another tier of probate. $100,000 to $300,000, another tier, and then $300,000 and above, what we call a general administration. So it depends on the value of the asset, but yes, it would have to be probated.
Yeah, so that goes back to updating your trust, right? And the importance of that.
Yeah, and for most people who have a trust, there's probably folks here who have trusts, you probably just haven't updated or funded the trust. The term we use is fund the trust, meaning take title to your accounts or assets in the name of the trust. You know, I don't know if we have physicians in the room, but they tend to be the worst at keeping the trust updated. Very busy, a lot of things going on in their lives, and they just don't keep them updated. So big generalization there, but that's been our experience. Question in the back?
Yeah, we're talking trust. Are we talking revocable or irrevocable?
Revocable, yeah. Irrevocable becomes a whole different discussion, another semester-long course in law school. But what I'm speaking of is strictly revocable, living inter vivos trust.
So if you have an old will, is it better to amend that will or avoid that will?
So that's really case dependent. Oftentimes for me, it's more cost effective just to do my own instead of trying to pick through the provisions of what someone else did. It generally is just, it's easier, more cost effective to just start afresh.
So what happens to the old will then?
It's revoked. I mean, the new will provide that I hereby revoke any and all prior wills, codicils, or amendments thereto. So that's sort of the first line in the will provides that you're revoking any prior testamentary instrument.
If you have a lot of vehicles, do all vehicles have to go into the trust?
That's it must be because we're a Hot August Nights community. That's a common question. Recently, my most vehicle-intensive client, he had 40 vehicles.
What? Jay Leno.
Yeah, I'm not quite at that level, but he loved to fix up cars. He buys beaters, as I saw them. His wife even agreed they were beaters and fixed them up. Vehicles are a wrinkle because a lot of insurance companies hate insuring vehicles that are owned in the trust. So what we do in our firm is we let you keep the title in your name or your joint names, and we do an assignment, a separate document whereby we assign, convey, transfer your vehicles to the trust. So there's a written evidence that you intend for the vehicle to be owned by the trust, but we're not changing title. The other reason is we don't want you to die in line at DMV. So that's a real risk.
It is. Struggle is
Yes.
real.
What is the point or the benefit of having a will if you have a trust? Why would you have a will?
Because what I just alluded to, people don't update. People don't put their assets in the trust.
So the will comes in behind you, you've established a trust and then you put a will for changes that...
Not changes so much as just people don't update their trust. They'll go out and open up a new E-Trade account.
Right.
They think they're the next Donald Trump and they buy a couple homes and they don't put them in the trust name. And so the will provides that those assets, after going through probate, get poured over to the trust.
Okay.
It's essentially malpractice for an attorney to just give you a trust. And I've unfortunately seen that in this community. There are attorneys who will just do a trust. I'm like, where's the pour over will? Well, they don't have an explanation. So
Interesting.
it's backup protection.
Okay.
Yes.
So kind of the same question was asked about probate. So if the trust is seriously outdated and you read through it, you go, gosh, this doesn't apply anymore. Do you revoke that and start fresh, or do you have to amend it?
Good question. Yeah, with trust, it's different. Usually, because of the titling of assets, the funding of the trust is so vital. We don't like to revoke a trust that has assets. What we do is do an amended and restated trust agreement, whereby we basically go in, scrape out all the current terms, and insert fresh terms or updated terms. So we're not changing the name of the trust. We're changing the trust terms or the provisions. So it'd be like, we're knocking down the house, but we're keeping the foundation, so the address isn't going to change. Yeah.
So if you have assets in an LLC, how do you define that for the will and the trust?
Well, hopefully your trust is the member of the LLC or the owner. Your trust ought to be the owner, or if it's not, then we can do, similar to the motor vehicles, an assignment whereby you assign and convey your LLC interest to the trust.
Does that go for corporations as well?
Yeah, different form of transfer instrument, but yes. In the back, yep.
So.
Is this the mascot?
Yep.
I'm sorry. No, I've heard talking trust, but there's these charity trusts, or it be involved with that. Is that part of the picture? But like charity leftovers or something like that?
Yeah, there's charitable remainder trusts, charitable lead trusts.
Yeah.
I mean, I'd be happy to charge you and have that discussion with you, but that's a little beyond the pizza payment I got tonight. So actually, I'll say this: I'm really grateful to Greg. He gave me money to stack that money.
Salad too.
And salad.
Yeah, sorry.
And there's
salad.
some dessert there.
Oh, dessert too.
So,
And free beer.
yeah.
The charitable trust that is more involved, but yeah, those are out there, and those are, onto your question earlier, those are irrevocable types of trusts.
Are those playing?
Oh, you're really pushing this, aren't you?
Yeah, yes.
What's that?
You're really
Nothing.
pushing this. I told you that's outside the pay scope of this stuff.
I know, but I don't take no for an answer. I married an Italian woman, and if I took no for an answer, you're gonna get anything.
And I'm sorry, I cut you off your question.
No worries. But what about, like, for that whole tax planning? That's part of the reason we're doing the trust, is tax planning, and I know it's estate planning too. How does what are the benefits? Do I need a charitable trust or not? I'm not Bill Pennington, I understand that.
And for some people who are charitably minded, who don't have children of their own, don't have any heirs that they want to receive assets, those types of trusts make a lot of sense. So we can do some creative planning to help give them some income during life while providing a great charitable benefit at death, or vice versa, do some great charitable giving during life while providing for the distribution of the assets to their heirs or intended beneficiaries at the end of their life. So it really just depends on the client's wishes, if they are charitably inclined, but certainly there's a tax consideration in that as well. I think that's the sign. Like,
All
don't
right.
lie.
Well, thank you, Jason. Yes.
Okay.
Perfect time.
Retirement accounts interact with trusts, like IRAs and 401ks. Do you put them in there, or are they named as a beneficiary?
Good. You guys are really going outside the scope of this. This is tough. So a lot of financial advisors will tell their clients never name your trust as a beneficiary of a 401k or an IRA. That's a good baseline rule, but you can insert provisions to allow the trust to be the beneficiary of retirement accounts. But you must have these special provisions, and they're called either see-through or look-through or conduit provisions in your trust. But you don't want to just, as a matter of rule, you don't want to say don't ever name the trust, or just go ahead and name the trust in the retirement accounts. It really needs to be examined closely, and the trust probably needs to be amended and updated to allow for that, to at least allow for the most tax-efficient disposition of those assets. Because the rule, when the financial advisors say never name your trust as a beneficiary, 5-year mandatory payout when a trust or estate is named as the beneficiary. So typically with an IRA, if an inherited IRA, you can use your life then as the measuring stick for RMD's purposes, and you can distribute out the IRA over a long period of time. You can stretch it out, stretch IRA provisions. People don't like the mandatory 5-year payout. Well, there are provisions you can insert into the trust to avoid that 5-year mandatory payout. So,
Would you put them in your trust when you're living?
no, you can't. I mean, it's not, you can't name the trust as the owner of those accounts. The government wants to know who the owner is. They don't like it when it's getting moved into a trust. The trust, like I say, can be the beneficiary, but with special provisions.
All right. Thank you, Jason. And by the way, he's going to be sticking around to answer any questions. And certainly, I'm sure he has plenty of business cards if you'd like to schedule an appointment to talk to him in person, one-to-one. So thank you, Jason.